Good morning from Bangkok, and welcome to the FDA and 510Ks, The Reckoning, Part 4. My name is David Lawrence. I'm an Illinois qualified attorney living and working here in Thailand since 2010, with my relevant experience being the in-house counsel for the parent company of Sri Trang Gloves Thailand Company Limited, where I was responsible for FDA-related matters, particularly with respect to gloves, but I guess I should mention that most of the material here applies to anything that needs a 510K, not just gloves. So tell your friends, like, share, subscribe. Okay, in the past, this is the reckoning, right? So this is a pretty serious topic, and maybe I was a little bit over dramatic in my videos yesterday, trying not to be. So what in the first three videos, I tried to convince you that there will be a reckoning. Because in my other videos, I showed you how easy it is for unscrupulous manufacturers, distributors, and anyone in the supply chain to trick the FDA just by ticking a box and getting, maybe not getting a 510K. That's a little bit more difficult, but not that difficult. Or associating one with their registration, then filing a false registration in the FURLS database. Very easy to make it look like you've got a factory, right? Okay, then I also tried to convince you that if the FDA so chooses, and I believe from information I've received that they are so choosing to get to the bottom of this, no matter where the bottom may be, which country, whether Thailand, Vietnam, Malaysia, Indonesia, China, they will be able to get to the bottom of it. They have enough, either they'll have enough relationship or they'll have enough leverage through sanctions or blocking product, whatever leverage they need. They can shut down the market to any country at any time. We saw that in the trade war, right? It didn't shut it down, but it just added tariffs and essentially shut down that. So they can get the information. They want to get the information. And then in passing, I mentioned that ignorance is no defense. Okay, that's what I want to focus on here. So we're going to have to get into a few legal concepts. So you may have been saying, David, that's all fine and good, but what's that got to do with me? I looked at the manufacturer and I looked at the 510K and I saw that they had the ISO 13485 and I know that, or I was pretty sure, I did everything I could possibly do to make sure that the device coming in was legit. And I'm going to tell you, it doesn't matter. Okay, the way that the FDA is set up, they can ding anyone, right, in the supply chain. But don't take my word for it. Let's go look at a global law firm, DLA Piper, and there's a branch here in Bangkok. I have a few friends and connections working there. Great law firm. 4 years later, federal court upholds conviction but harshly criticizes off-label prosecutions. That didn't mean much to me when I read it because it's pretty specific, but let's go down to this FDCA and off-label promotion. Okay, the Food, Drug, and Cosmetics Act, the FDA's act, criminalizes adulteration or misbranding, keyword, of any medical device, tobacco product, or cosmetic and interstate commerce, that's another word, interstate commerce, including the introduction or delivery of adulterated or misbranded products into interstate commerce. Okay, you, by selling, are introducing your medical device into interstate commerce. Criminalizes adulteration. So it doesn't matter if you manufactured. If you're the one that put it in, you can get dinged. Okay? There is no escape from the massive power of the federal government should they choose to wield it against you. Okay, well, I'm running out of time, as the indicator up there says, and yeah, I'm too cheap to buy the full package and go more than 5 minutes, but I'm going to get into misbranding with the next part right after this, and misbranding, just as a preview, it means misbranding, but it also means a ton of other things. Essentially, that's it for now. Thank you. Like, subscribe, share. Bye.